Uh, Hello, everyone. My name is Stephen Lee. I'm a professor and the Associate Dean for Faculty Research and Development here at UCI. I have the great privilege of serving as your moderator for today's event, Setting the Record Straight, Primary Sources and Evidence on Comfort Women Issues. Now, I'm going to step back momentarily, but before I do, I just wanted to provide you with a couple of pieces of logistical information. So first, through the magic of Zoom, we're able to reach a global audience. And so many of our audience members and panelists are Korean speakers. So you'll notice at the bottom of the Zoom window, a button that says interpretation. So if you would like to get an interpretation of today's proceedings, either from Korean to English, or from English to Korean, go ahead and click on the relevant channel and you'll be able to participate and listen to the proceedings. So that's the first. Second, I just wanted to give you a little bit of context for the event. So, UCI has had a long-standing relationship with Korea University. Korea University, of course, itself has been very active in developing bringing attention to issues of global importance. And so we have a wonderful event today that has a number of different participants. So aside from UCI Law School, we are delighted to be joined by Korea University and then the UCLA Center for Korean Studies, our neighbor up the 405. And then with the Comfort Women Action for Redress and Education, also known as CARE, which is an organization dedicated to working with and advocating on behalf of comfort women. I should say that at the broadest level of generality, today's event is about the experience, to highlight the experiences and struggles of comfort women who are survivors of state-sanctioned and coordinated sexual assault by the Japanese government during World War II. Now, while the national origins of comfort women spans the globe, a majority of these comfort women were Korean, and for this reason, we'll focus on that group for today's event. Now, today's event will be divided into three parts. After we have a set of opening remarks, the first panel will focus on challenges and new possibilities related to documenting the historical experiences of comfort women. Second, the next panel will discuss legal claims that have been and might be advanced with and on behalf of comfort women. And then third, a group of panelists will discuss broader strategies related to community education. And then at that point, we'll open it up to broader discussion. So if you have questions, please drop those in the chat or in the sort of Q&A function, and I will be sure to gather them and share them with the panelists at the end. Okay. So with that, let me turn things over to our different speakers for the opening remarks. Why don't we begin with Dean Song Richardson, who is here representing UCI Law School.
Good evening, everyone. I am so honored to be able to welcome you here this evening to this important conference. As Professor Stephen Lee has already laid out, this is an issue that needs more attention, continues to receive attention, but I'm honored and grateful that our law school, UCI Law, is a co-sponsor of this event with Korea University School of Law. The database that will be the focus of tonight's discussion, that was developed by a Korea-based NGO, and that NGO translated into English important archival material on comfort women from the time of the Japanese occupation. So we'll be able to learn much from those materials, and I want to express my gratitude and thanks to all of our panelists for what I'm certain will be an important and rich and engaging discussion. Now, as Professor Lee already mentioned, this symposium is part of an ongoing collaboration between UCI Law and Korea University School of Law. And I am so proud, I just have to say this, I am so proud to have been the dean when this close collaboration between our two schools was first established. And over the years, we have been able to engage in scholarly exchanges, and we have built such deep and meaningful friendships between our two communities. In fact, one of the first acts that I made when I became the dean at UCI Law was to participate in a symposium at Korea University. And so I think it's fitting that my last welcome as dean of UCI Law is for this particular symposium. It means so much to me to co-sponsor this event and to be able to be here with you to give this welcome. Now, there are a number of people I'd like to thank for making this event possible. Of course, there's Professor K.S. Pak. He has been instrumental in helping us to build this collaboration with Korea University. I'd also like to thank Dean An for supporting this important symposium this evening. I also want to express my appreciation to Phyllis Kim, the Executive Director of Comfort Women Action for Redress and Education, and Nam-hee Lee, Director of UCLA Center for Korean Studies. And last but not least, I must also thank my wonderful colleagues. So first, there's Professor and Associate Dean Stephen Lee. You have already heard from him. There is also Rabi Kadri and Aaron Hebert. All three have been such key players in organizing and making this event possible. So once again, I welcome you to UCI Law and to this important symposium. I'm thrilled that all of you are here and that we are co-sponsoring this with Korea University School of Law. So thank you so much for being here this evening.
Thank you, Dean Richardson. Next, we will hear from the Dean of Korea University Law School, Dean Hyojil An.
안녕하세요. 거기 오후 저녁이라고 5시죠? 예, 여기는 아침입니다.
It's 5
예,
p.m. there. It's 9 a.m. there. Great to see you.
로스쿨 교수님들 환영합니다.
I would like to welcome the members of UC Irvine Law School faculty
정말
and
환영하고 감사하고요.
Dean Richardson.
2018년 저희
Thank you and welcome.
해주시고
Especially want to thank Stephen Lee, who came to our campus in 2018 to teach our students and oversaw today's convening. UCI Law is our main partner for cooperation and exchange. To promote the relationship with UC Irvine, we created American Law Center. It is the focus of our internationalization, globalization efforts. We convened our first Shutter Conference May 2017 and have convened this joint conference every year until last year. Our 5th Shutter Conference will be on the most important issue of wartime women's human rights, namely the Japanese military's so-called comfort women. As we learned from the Ramsey fiasco in the international community, there are efforts of revisionism. We need diffusion of documents and evidence of the truth about the comfort woman system in English language. Especially in the United States, where Korea-Japan relationship is very much influenced. It's important to build that consensus. I would like to congratulate and commend Comfort Women Action for Redress and Education, who have long worked for education and information within the US, and UCLA Center for Korean Studies, who will host the online archive, and Korea University's American Law Center, who have supported translation of the evidence material. I expect excellent discussion from international human rights perspective, especially from Professor Kang Byung-gun, our own faculty, and UCI law faculties. Thank you.
Thank you, Dean An. Next, we will hear from the Executive Director of CARE, Phyllis Kim.
Hello, it is my great honor and pleasure to welcome every one of you to this very meaningful discussion about the English resources for the comfort women issue. I sincerely thank Korea University American Law Center, UC Irvine Law School, and the Center for Korean Studies at UCLA for co-hosting this event, and our distinguished speakers and
감사드립니다. 그 외에 저희 저명한 연사분들, 패널분들.
In 2016, California Board of Education adopted the comfort women issue as one of the topics in the high school world history curriculum. Since then, CARE and our partner organization, CWJC in San Francisco, have been working very hard to provide lesson plans, teachers' guidebooks, and source materials for the teachers in California and beyond. This UCLA CKS online archive is our another effort to set the record straight, focusing on the primary sources, which had not been made available in English before. The archive is a true collaboration and also still in progress with many dedicated people, and please bear with me as I'd like to recognize everyone's effort. First of all, the translation of the annotations of the source materials was funded by the Research Institute on Japanese Military Sexual Slavery and the Women's Human Rights Institute of Korea. We thank very much. And the annotations for the primary sources have been graciously provided by the Northeast Asian History Foundation and Jin Sung Chung's team at Seoul National University through Seoul Metropolitan Archive, and the scholars in the field, Byung-Ju Hwang and Hein Han. The translation and editorial team included Drs. Jimin Kim and Sung-hee Shin, and Professor Alexis Dudden and Professor Bonnie Oh. Professor Pei-Pei Chu provided the Chinese victims' testimony and translation and helped us with the glossary. I also thank Chrisanne Snyder and Stephanie Lee from CARE for their sleepless nights and hard work. CARE is deeply grateful for Professor Nam-hee Lee for working with us to build this online archive for the Comfort Women issue under the Center for Korean Studies website, which will be launched on August 13 of this year, simultaneously with the Research Institute on Japanese Military Sexual Slavery in commemoration of the 30th anniversary of the first public testimony of Grandma Hak-Sun Kim. Last but most importantly, I can't thank enough Professor Kyung-Shin Park, K.S. Park of Korea University Law School's American Law Center, who has been more than instrumental in pushing this project forward and organizing this webinar. We have a lot to cover today, so I'll end here and I'll turn this over to Professor Lee. Thank you.
Thank you so much, Phyllis. Finally, we will hear from Professor Nam-hee Lee, the director of UCLA's Center for Korean Studies.
Thank you. As the director of the Center for Korean Studies at UCLA, I am deeply honored to be part of today's event. Today's event is continuing the 3 decades long Redress movement by and on behalf of the comfort women in South Korea and in transnational communities. In the US as well, there has been a persistent grassroots movement participated by ordinary individuals and many civic groups to raise awareness among and to educate the general public about the issue of comfort women. And as we've already heard, the grassroots movements have made possible the congressional resolution asking the Japanese government to acknowledge, apologize for, and accept responsibility for its comfort women's system, the construction of the peace monuments in places such as Glendale, Atlanta, San Francisco, and the 2016 California State Board of Education approval for a history social science framework for California's public school that includes comfort women in the 10th grade world history curriculum. And again, as we've heard, CARE and other organizations have been instrumental in bringing together scholars and educators to make the primary documents on the comfort women available to the teachers and public. And today's event is to make such effort public and also to launch, well, pre-launch the digital website of such materials at the UCLA Center for Korean Studies. I would also like to take this opportunity to express my warmest gratitude to Professor Kyung-Shin Park at Korea University Law School and Phyllis Kim at CARE, who have been working tirelessly over many, many months to make today's event possible, despite many difficulties along the way. Thank you.
Thank you, Professor Lee. Okay, so with that, our opening remarks have concluded. Let's now turn to the first substantive panel. The first panel will focus on documenting the comfort women system. And here our focus will be on this new database of documents, establishing the contours and the existence of the comfort women system. With us today, we have two experts. Our first panelist is Professor Alexis Dudden. She's a historian by training and a member of the faculty at the University of Connecticut, their history department. She publishes regularly in print and online media and is completing a book project tentatively entitled The Opening and Closing of Japan, 1850 to 2020. Our second panelist is Dr. Hae-In Han, who is a research fellow at the Asia, Peace, and History Institute and a visiting researcher with the Center for East Asian History at Sangkyukwon University in Seoul. Dr. Han is a scholar of modern and contemporary Japanese history. Okay, so each panelist will speak for about 15 minutes and they'll speak to, again, the sort of exciting opportunities presented by this database. So with this, why don't we begin with Professor Dudden.
Thank you so much, Professor Lee, Professor Park. I cannot express my personal gratitude for this opportunity. Dean Richardson, Dean Han, thank you so much for making this event possible. And I have to give a personal shout out to my sunbae, Nam-hee Lee, because it's pretty cool to see Professor Lee in this capacity. And as a historian, also, I have never met Professor Chong-Mu Chae in person, but to see Professor Chae on my screen right now I am getting goosebumps because I have learned so much. And thank you. 반갑습니다.
Thank you.
Thank you so much. This is just kind of like, oh my God, that's Professor Chae. And so Zoom is terrible, but it's wonderful in this respect. And so what I would also like to confess is I went to my office at the University of Connecticut for the first time today. I guess it's May 2021, for the first time in 16 months. Since March 2020, so that I could go get some materials. And I did not make a PowerPoint, but this is a document from 1992 that I purchased as a graduate student in Japan. And this is what happened in Japan in the 1990s. Local activists, scholars, collated this is from the Kobe High School Teachers Union, and they collated what was coming out in the newspapers. And forgive me for this not irreverent but not put together presentation, in the sense that this is what was happening in the 1990s when Kim Hak-sun made her presentation. We as historians and believers in the truth learned, and we had to grab what was going on. I went to the archives. I also pulled this out of my office today, something I made when Professor Lee knew me as a very junior graduate student. This is just a document from the Japanese archives. It doesn't exist anymore in the archives, but I have a copy of it. And does that make me part of the state secrets law? I don't know. And I'm saying this all randomly because that's how we were doing the history in the 1990s, when we had people who had survived the horror, former survivors coming forward with the truth. People were going to the newspapers, people were running around in archives, pulling out what we could. And what Phyllis Kim, Kerr, Dean Richardson have made possible is an archive that will survive. And not only an archive that will survive, but an archive that is in multi-platforms, is available in English, which we all know from even this Zoom webinar is what we need to teach the truth. And what we need to do is to preserve the truth into perpetuity. As Professor Lee mentioned, as Phyllis mentioned, in 1993, with the Kono statement from the government of Japan, the truth happened. We learn from history, we teach history. How we are able to do that changes with each generation. And now with the UCLA archive, the UCI archive, and Korea University, we have the ability to do that in perpetuity. And I am incredibly grateful, because otherwise we're all running around looking for scraps of paper that each time a denialist says, you don't have the evidence, this doesn't exist. We have the evidence. And now we have the ability to teach it in so many classrooms. And that is the only point of this history, right? None of us is here to trash the government of Japan. We are not here to blame Japan. We are here to teach the truth of what happened, and we have hundreds of documents. And we now have hundreds of documents that CARE, with the collaboration of all the groups sponsoring this wonderful event, have made possible to put on a digital archive. And I just wish I could share more, other than my gratitude as a teacher to share this forever. And thank you so much.
Great. Thank you, Professor Dudden. Okay. Now, before we turn things over to Dr. Han, just a friendly reminder to please drop any questions you have using the Q&A function. And again, I'll be able to collect these and revisit them later in the program. Dr. Han? You need to unmute yourself.
예,
There
제
you go.
목소리 들리시나요? 예. 예, 저는 한국말로 발표를 드리겠습니다. 예, 우선 저는 PPT를 사용할 것이고요. 예, 제가 오늘 말씀을 드릴 것은 제도의 예외적 존재로서의 일본군 위안부라고 하는 것을 발표를 드리도록 하겠습니다.
We'll talk about the nature of comfort women as an exception of the system. I studied abroad at Hokkaido University, and I studied Japanese history.
사실 위안부 피해자들이 기본적으로 1990년도에 알렉시스 더든 선생님께서도 말씀하셨듯이 목소리를 내면서
As were known to the world, the issue of comfort women were known to the world by the testimonies of the victims through public media in 1990s. And because the victims are here now, we think of the issue as that of a human being. And because of the similarities through sexual damage, some of the researchers have shown tendencies to deliberate on this issue in relation to the old licensed prostitution. often regardless of a special circumstance of comfort women. Today, I want to talk about the laws and regulations of Japanese government. And after 1937, the documents left by Japanese government and military show a system in which comfort women were not considered human beings, but commodities of military supplies.
1931년 만주사변부터 시작해서 태평양 전쟁, 중일 전쟁과
From 1931 Manchurian War through 1937 and through the Pacific War, the war has continued. There is a breaking point between 1937, before and after 1937.
37년 이후에 어떤 제도를 썼기 때문에 그 37년 이후부터
After 1937, it shows a new system imposed on comfort women.
공문서를 통해서 일본군 위안부의 제도는 어떻게 성립이 되어 있는가라고 하는 것들을
So through the official documents, we look at the formation of comfort women system. So we look at first laws and regulations concerning establishment of comfort stations, and secondly laws and regulations concerning qualification of comfort women recruited to comfort stations. Thirdly, the laws and regulations concerning management. Finally, and lastly, regulations and laws concerning the death of comfort women. With the close inspection, you'll see that there are different laws and regulations, and there are clear breaks between these laws and regulations because the laws and regulations were not made thinking of comfort women as human beings. That's why there's no continuity between these package of laws and regulations. So comfort station is a military facility.
개정을 하면서 위안
There is
시설을
a rule called field military facility rule.
개정을 하면서
And as this rule was amended, the comfort station was established. So far, according to the research in the past, the purpose of establishing comfort stations were discovered to be prevention of venereal diseases among Japanese soldiers, prevention of sexual violence in the war area against local residents, and controlling women, controlling soldiers with a morale booster. However, not much prevention of sexual disease happened, and I think that these are all superficial reasons. The real, the more fundamental purpose is to reduce the cost of war, because they mobilized not a regular army force, but first reserve and second reserve force who are not well trained, and as they were stationed for a long time, they had to be compensated or rewarded with the trips back home for rest. But in Japan, in order to reduce the cost of giving these trips to Japanese soldiers, they changed the rules.
그 조짐을 보이자 요 사람들
Japan, as Sino-Japan were prolonged, they wanted the soldiers, the Japanese military made soldiers stay longer in the battlefront. And in order to do that, they had to build these comfort stations.
그래서 요 전투 장소에 있는 좀 이따 또 설명을 드리겠는데요. 요 주보라고 하는 것에 위안 시설을 설치하는데 원래 이제 위안 시설이라고 하는
So
것은
comfort stations were built in these field canteens.
성적인 부분을 만족시킬 수 있는 위안 시설을
The purpose was to satisfy the sexual needs of Japanese soldiers.
모두 군의 내무 규정으로 만든다라고 하는 것이 원래입니다. 원래의 목적입니다. 그러니까 실질적으로 말했을 때는 성병 예방이라든지 군의 사기 진작이라든지 뭐 이런
Morale boosting, prevention of venereal disease.
실질적인 목적은 전비
Those were purposes that were covering the real reason, which was reduction of the war cost. So comfort stations were there even from Manchurian War in 1930. But back then, it was mainly the Navy force.
전장지에 있었던 공창, 사창을 이용을 합니다.
So
그래서
soldiers stationed in, for instance, Shanghai used prostitution facilities there. Starting 1937,
주보 규정을 개정을 해서 그 영내에 위안 시설을 만들 수 있게 합니다. 그러니까
the rules were amended so that comfort facilities were built within the military base.
37년 이후가 되면은 군의 시설의 하나가 되는 것입니다. 그리고
So comfort facility becomes part of the military facility. And after 1937, they managed the comfort facility within the military base and expanded the level of management. And this canteen is also called PX. These rules were written by the Ministry of Army, which is part of the Japanese cabinet.
이런 방식의 위안 시설을 만들게 되는 것입니다. 이 이제 주보
It is according to these rules, and you can see the amendment to the canteen rules. Here clearly it says comfort facilities can be built.
군인들을 위안해야 될 필요성이 있기 때문에 해야 한다라고 하는 것을 이제
And here the reasons for building such a facility
구조가 그럼 어떻게 되어
boost the morale.
이게 지금 이제 통수 군무입니다. 정부가 있고요. 그 다음에 이제 통수권 군의 조직이 있습니다.
So there is a military establishment and there is a government establishment.
주보 규정 개정을 하고요. 그 다음에
And Ministry of Army, they make the rules. And on the right side, the military establishment, they execute the rules.
여기에서 이 주보 규정을 시행하는 데 있어서 내무 규정을 만들어서 그 위안소를 관리를 하고 위안부들을 관리하는 것입니다.
So the military establishment made the lower regulation, low level regulation.
육군성에서
And
주보 규정을 통해서 관리를 하게 됩니다. 그리고 요 이제
the comfort station managers were managed by the government establishment.
위안부를 관리할 수 있는 그 규칙이라든지 이런 게 하나도 없습니다. 그러니까 기본적으로 말했을 때 성병 관리를 한다라고 했을 때는 그거는 군인을 관리하는 것이지 위안부를 관리하는 것이지.
What is notable is that comfort women themselves do not appear in any of these regulations. So even in the rules, when it talks about prevention of sexual disease, what they meant was prevention of sexual disease on soldiers. It was not for preventing sexual disease of comfort women because they just do not appear in the rules. So there
외무성에서
was
요그
absence of any rule protecting the health and safety of comfort women.
법역을 넘어가는 방식을 알려주는 것이지 그 도항 규칙을 통해서 위안부를 관리하지 않습니다.
So there are rules about traveling, but they are also not built for comfort women. Yes, the rules are told to inform to the comfort women, but the rules don't mention them. And each army base make their own low-level regulations in enforcing these higher rules made by the Ministry of Army.
이걸 쭉 보게 되면은 기본적으로 어떤 사람이 위안부가 되어야 하는가라고 했을 때
So here is
군이
the rules
구상한
about
것은
qualification of a comfort woman.
10세의 여성인데요.
So
이게 이제 전차금이라고 하는
the
건 미리
Ministry of Army first thought of women between 16 and 30 of age.
업자가 먹는다라고 하는 것을 상해 파견
And
여기 이제 작부 모집에 관한 건이라고 하는 공문서 속에 있습니다.
and it says licensed prostitutes older than 18.
잠깐만요. 요거는 기본적으로 공창제라고 하는 규정과 맞지 않습니다. 공창제라고 하는 것은 18세 이상의 여성이 돼야 되는 건데
So
요건
the existing rule on licensed prostitution required women to be older than 18. But 1938 military's new rule allowed a woman between 16 and 30 of age.
국제법에 위반이 되기도 하고요. 일본 내에 있는 형법에도
And
위반이
then the government realized that this new rule will violate international human rights treaties that were existing back then, and also other criminal laws of the country. So Ministry of Home issues a notification and required comfort women to be older than 21 and with the experience in prostitution.
일본 내지에만 해당하는
So this was the rule that was enforced only within Japan. Outside Japan, in practice, this notification was ignored. And also, if you look at this document, if you look at the advertisements, recruiting comfort women, this proactive notification from the Ministry of Interior were not applied.
18세, 31세, 17세에서 31세로 이렇게 내기 때문에 조선에서는 내부성 통첩이 이루어지지 않았다. 그리고 요거는요,
So this graph shows the age distribution.
포로 수용소에서 있었던 조선 여성 위안부를 포함한 조선 여성의 연령이고요. 그 다음에 요 주황.
So Ayutthaya prison and Shanghai Women Mutual Aid Association. That's the red graph. The blue graph is the Ayutthaya human prison. It shows the age of women who were found in these facilities. And victim Kim Bok-dong was included in this Myungbu. This is the list of comfort women. And the yellow graph shows age of comfort women who registered with the South Korean government. And this shows the age at which they were taken into comfort stations. And you can see that many women among the women who registered with the South Korean government, most women were taken in
나머지 그래프
at age 15 through 17.
연령이 되려면
Now, the ages in the red graph and blue graph, these were the age of the women who were found at the facilities. So if we extrapolate back to the age when they were taken, we have to subtract 2-3 years, which match the young age at Korean women were taken from Joseon.
구상한 그 연령 그대로 끌고 갔다. 21세기
So Japanese military's original design of recruiting young women between 16 through 30, that plan was actually executed. It was not stopped short by Interior Ministry's notification.
예, 그렇게 끌려가고요. 그 다음에 이제 어떤 방식으로 끌려갔는가라고 했을 때요. 요 그래프를 이렇게 보시면 이거는 마카오에서
How they are taken.
일본 군과 위안부들이 끌려가는 방식인데요. 이게 2년
And it
동안 끌려가는 거거든요.
shows how they were taken into comfort stations.
동원될 때 위안부는 10명이 동원됩니다. 이 10명
So when there were 347 Japanese soldiers were stationed, 10 comfort women were stationed together. So 10 women provided were forced to provide for 347 women. And you can see that they needed, so to speak, a durability as a requirement of women. That's why we recruited a young woman.
보시면 이동은 어떻게 했는가?
Now I'm going to talk about the laws and regulations concerning movement of comfort women.
이게 이제 좀 간과하는 건데 제국이라고 하는 것은 기본적으로 이제 전쟁을 하면서 확장이 되는데요.
This is the empire that expanded through the war.
점령지를 사이에 두고 요 법역을 결정합니다. 이게 이제 공통법.
And there
그러니까 일본이 내지에 그러니까 제국 헌법을 그대로 식민지에 적용시킨 것이 아니라 그 안에서 이제 제국 이제 조선
then
통조권을
there is a common law jurisdiction that concerns the occupied territories.
그런 방식으로 할 수 없기 때문에 법역을 결정을 합니다.
So the Japan's own law is not just applied to these territories. There's a different law that is applied to those occupied territories.
사실 조선적으로 통치를 하고 타이완인은 타이완적으로 호적으로 통치를 하는데 타이완에게는 제국의 국적을 주는데 조선인에게는 사실상 국적을 주지 않습니다. 왜냐하면
So it's not through nationalities, but residential registrations through which people were governed. And Japan granted nationality, Japanese nationality to Taiwanese, but not to Koreans.
중국 지역 일부는 그 일본의 민법이 그대로 통용될 수 있는 법역을 결정합니다.
So in some areas, Japanese civil law was directly applied.
이동을 할 때는 여권이 필요 없고 도항 정책으로만 움직일 수 있어요. 그런데 문제는 전쟁이 수행되면서 남방 지역으로 확산이 되면서 실질적으로 일본인이든 식민지민이든 여권이 필요한 지역이 생기는데요. 그럴 때 조선인 위안부에게 있어서는 여권을 발행하지 않습니다. 예, 이게 바로 그건데요.
Passports were needed for comfort women to travel to comfort stations, but passports were not issued to them. And that's how they were transported to comfort stations. And if you look at this document, it says there's no need to issue passports for comfort women.
발급하지 말고 군의 증명서에 의해서 군용선으로
They can travel through military ships with military issued identifications.
여권을 발급해주지 않고 군의 배를 통해서 군 증명서를 가지고 그걸로 이동을 하게 됩니다. 그러면 어떻게 될까요? 여권이 필요한 지역에 여권이 없을 경우에는 불법 체류자가 되고요. 그러면 이 위안소에서 한 발짝도 나갈 수 없는 상태가 되는
So
것입니다.
not having this legal status made it legally impossible for comfort women to take even one step
요거
out of
다음으로
comfort station.
그 사료에서는 사실 귀환을 할 때 이 위안부들을 어떻게 할 거냐라고 합니다. 그러면 외무성하고요, 여기 총독부하고 서로 미뤄요. 우리들이 책임질 수 있는 존재가 아니다. 왜냐하면 여권도 없죠. 총독부 입장에서 봤을 때는
So when comfort women are to come back, there's an issue of how they're gonna come back legally, and the colonial administration and the military administration push that task to each other, deserting responsibility.
조선이나 타이완에서 남방 지역으로 동원된 위안부라고 하는 것은 여권을 발급해주지 않기 때문에 무법적인.
So the comfort women who were transported to Southeast Asia, because they had because they were not issued passports, they were again not given any legal existence. Okay. What regulations existed for death of comfort women? There was no regulation at all. This was a novel written by Park Yong-gyu, a Korean soldier. He was mobilized to Southeast Asia, and he was in charge of taking care of dead bodies from the war. And he says, but for the case of a missing comfort woman, Japanese military police didn't feel any need to make any complex document, just like one for the military engineer, because comfort woman is not a human being, but one of the listed items on the military supply and support.
하나 없어졌다는 데 대해서 공병과 같이 복잡한 보고서를 만들 필요는 없었다. 위안부는 인간으로서가 아니라 물품으로서 장부에 오르는 존재이었기에입니다. 이것이 소설에 쓰여져 있는 거지만 지금까지 살펴온 바와 같이 주보 규정.
Of course, this was a novel, but still it reflects, because he was actual soldier in charge of death.
그런 존재였다라고 하는 것으로 취급이 된 겁니다.
And comfort woman's death was not recorded or taken care of.
어디로 갔지? 네, 결론적으로 봤을 때 일본 군성, 즉 일본 정부가 주보 규정이라고 하는 규정을 만들.
Comfort station was formed following the regulation of a field canteen by Ministry of Army.
각각의 군대가 전장지에서의 상황에 따라서
And each military base made the comfort facilities using their own low-level rules. And Yoshimi Yoshiaki explained that there were different forms of comfort stations. The one managed by military, the one used by the military. But I think that classifications are not important, because whether managed or used or operated, it was because the difference came from the circumstances of each different military base. It was all under, it was a variation, it was under the variation within the higher rule under which comfort women were treated as military supplies. So Korean Taiwan women between 16 and 30 in age were considered expendables for war efforts. They were to work for 2 years using their bodies.
일본 군이 전쟁을 잘 수행하기 위한 관리 체계인 것이고요. 예, 그리고
So this was a very sophisticated system, and it did not give any legal recognition to comfort women within the rules because they wanted to avoid responsibility for them.
만들어간 제도이고요. 그리고 철저히 위안부라고 하는 것은 예외적 존재, 제도와
So comfort women was an exceptional existence in the laws and regulations, where they were considered commodities for military supply.
Great. Thank you, Dr. Han. Thank you very much, Professor Dudden, for those remarks. Now, before we move on to the next panel, I just wanted to say that a few of you have asked about whether the database will be publicly available. My understanding is that CARE is still trying to finalize a few things with the database so that eventually it will be publicly available. But if you are interested in accessing it in the near future, it would be best to separately contact Phyllis Kim by email and to reach out to her separately. But I think the plan is eventually that this will be broadly available because it's still in development. It's not yet available. Okay, great, thank you. So let's turn to our second panel, which will focus on the legal claims for comfort women survivors. And this will focus on the various legal claims, the possible legal implications under international law and human rights law, and how those claims fit with this new database. We are fortunate to have two experts. Our first speaker is Professor Paul Hoffman. Professor Hoffman is my colleague here at UCI. He is the director of the Civil Rights Litigation Clinic. He's practiced civil and human rights law for more than 4 decades. He's a former legal director for the ACLU of Southern California, and he has written and spoken extensively on civil and human rights issues. Our second panelist is Professor Byung-Gun Kang, who is faculty at Korea University, where he's been a part of that community since 2007. He is a professor of international law. He is currently serving on the research committee on international trade law for South Korea's Ministry of Justice, and he is the past legal advisor to the Ministry of Foreign Affairs. So we will begin with Professor Hoffman, and then we will turn to Professor Kang. So Professor Hoffman.
Thank you, Professor Lee. It's a privilege to speak at this conference. I've worked on and off on this issue for many years, including with Phyllis Kim on issues relating to the monuments in Glendale. I'm going to focus on the availability of remedies in US courts. That's sort of my area of expertise. And I'd have to caution everybody that I'm a wild-eyed optimist when it comes to international human rights claims. So you may have to discount any optimism that comes out. But the main question here is the main vehicle to bring international human rights claims in US courts for the last 40 years has been a statute called the Alien Tort Statute, which has allowed human rights victims from around the world to bring claims in US courts for the violation of the law of nations, including the kinds of violations that are involved here, including rape, sexual slavery, and the other international human rights violations that I think are fairly obvious from the facts that have been developed. In the year 2000, there was a case, Wang versus Japan, that was brought under the Alien Tort Statute by 15 women from China, Taiwan, South Korea, and the Philippines, alleging that they had been subjected by Japan to sexual slavery and torture, and that those violated the law of nations, and that they were entitled to damages for the reparations for that in US courts. Their case was dismissed on two grounds initially. One was the ground that Japan was entitled to complete sovereign immunity in US courts. The second was that what's called the political question doctrine in US courts prevented the judiciary from adjudicating their claims because it would interfere with US foreign relations, in particular with Japan. That case went up on appeal. It was affirmed initially. It went up to the Supreme Court. The Supreme Court decided that Japan might not be entitled to complete sovereign immunity under US law because our Foreign Sovereign Immunities Act applied to the time period in question. And it might be that there was an exception that allowed plaintiffs to bring a case in US courts. But when the case went back down to the Court of Appeals affirmed the dismissal of the case on the political question doctrine, finding, and that was based largely on the intervention by the Bush administration, saying that it believed the political question doctrine should apply and the court should not get involved in these kinds of questions. In particular, the court should not get involved in resolving the dispute between Japan and Korea over the meaning of the 1965 Peace Pact and whether it enabled individuals to bring claims for reparations under that act. So that's not a good story, right? So the question is it possible to overcome this precedent? So since 2005, which is when the last decision was rendered, the Supreme Court has become somewhat more conservative and has limited the use of the Alien Tort Statute in human rights claims in various ways. So that's not a good piece of news. One good thing is that there's no categorical bar in US law against suing foreign sovereigns under the Alien Tort Statute. There's a case involving Argentina in 1989 where the court said the Alien Tort Statute applies to all kinds of defendants. Now there's a case that's up in the Supreme Court right now, on which I argued in December, Doe versus Nestle, involving child slavery in Ivory Coast, which might change that, but so far it hasn't. The other piece of good news is that the DC Circuit, the Court of Appeals, in the Wang case, did not decide the sovereign immunity issue. And so those issues are still open, at least theoretically. So what are the positives then? I think we've heard a little today, and there's more to be told about the international movement for justice for comfort women. That movement has only grown stronger, right? There was the 2000 Tokyo Tribunal. There were other developments along the way, HR 121, but the movement has only grown stronger. It's grown stronger around the world. It's grown stronger within the United States. I think, if anything, developments in international law make the legal claims even stronger. You've had decisions from the international tribunals for Yugoslavia and Rwanda about rape as genocide. There's no question that the claims that have been made are solid international law claims that really can't be denied, I think, and derive from norms that were applicable at the time that these atrocities were committed. So that movement's important. Now, the thing I'd comment on is that there was a time, well, back up, one group of victims did get justice. In the Holocaust justice movement in the 1990s, claims that everybody thought were barred by the statute of limitations. In fact, I was involved in cases in the 1980s that were dismissed based on the statute of limitations, making Holocaust justice claims. But the Clinton administration backed lawsuits that were brought in the 1990s on behalf of victims of the Holocaust, which led to massive settlements for the victims and acknowledgement of the huge crimes that had been committed. Unfortunately, by the time the Wang versus Japan case came to be, the Clinton administration was no longer. The Bush administration started. The Bush administration was hostile to international human rights claims generally, of all kinds, was not willing to put the political capital that the Clinton administration was willing to put into achieving justice for comfort women, for victims of apartheid, for many other issues. They preferred to have economic relationships, good diplomacy with allies, not rocking the boat, and they definitely were not supportive of claims for justice. So the question is, can the forces that led to the Holocaust justice movement, could they be applicable here in some way? One of the things that the Holocaust justice movement has was they had credible legal cases as a basis for the settlements. Well, I think there are arguments that there are credible legal cases here, very powerful cases, I think. Now, they might be difficult as legal cases, but they're certainly credible as the basis for some solution. The other thing that the Holocaust justice movement had were overwhelming moral arguments for justice. And I think there are overwhelming arguments for justice here. And it was the overwhelming moral arguments for justice that led to the successes in those in the Holocaust justice movement. It wasn't because the cases were airtight legal cases. In fact, I'm sure some of the judges that ruled on the settlements thought that the cases really didn't have legal merit ultimately if they came to pass. But what they were used for were the ability to overcome the limits of the legal system to achieve justice. And that took political courage by the Clinton administration to go after or to deal with some controversy with some of its closest allies, Germany in particular. And so what is required, it seems to me, in order to overcome the Wang versus Japan precedent would be for a Biden administration, one would hope, to change its views about whether the cases should proceed. If the Biden administration changed the Bush administration's statement of interest that they filed in that case, it would be a new ballgame. If the Biden administration changed its views about whether other sovereigns could be sued for these kinds of jus cogens norms or violations, that would be huge. And so the question is whether this incredibly vibrant movement that has developed in the last 20 to 30 years with all the documentation that we're talking about, the overwhelming evidence to support the violations, can somehow be brought to bear politically on an administration that might want to see justice done. And, you know, the way I look at these things is that you never know when the right moment for justice comes, right? I don't think there's any statute of limitations on achieving justice. There may be a statute of limitations in legal cases, but I think the Holocaust litigation experience showed that if there's political will and a desire to force a resolution of this issue, the US government has the kind of influence that could assist in finding some solution, whether that's through litigation. There are other ways to do it. I know there's been discussion about trying to convince Japan to have these issues adjudicated by the International Court of Justice. The particular vehicle, it seems to me, is less important than getting the political will of an administration that cares about human rights and righting this historical injustice to take action. And so that would be my hope, that we could do that. I'll stop. I know we have a lot of people to speak.
Thank you, Professor Hoffman. Now we'll hear from Professor Kang at Korea University.
감사합니다. 저는 고려대학교의 강병근이라고 하고요. 오늘 그 어바인 대학교 법과대학장님, 그리고 고려대학교 안효질 원장님, 그다음에 오늘 그 진행을 담당하시는 스테판 리 교수님 모두 반갑습니다. 저는 이제부터 그 제가 PPT로 만든 자료를 공유하고자 합니다.
I'll start sharing PowerPoint presentation.
네, 일단 국제사회에서 다른 공동체와 마찬가지로 법이 존재합니다. 국제사회의 존재 형태는 문서로된 조약이나 또는 국가들의 관행을 바탕으로 하는 관습, 그 다음에 각 국가의 법의 공통적인 요소들로 이루어진 법의 일반 원칙이라는 것이 있습니다. 지금 약 100년 전에 1920년대 국제사회를 보게 되면은 이 당시에도 국제법이 존재했었는데 다만 이제 국제법의 세밀화, 정교화 이런 것들이 별로 없어서 국가들은 뭐라고 생각했냐면은 국제법에서 금지되지 않으면은 국제법에 따라서 할 수 있다라고 생각을 했었습니다. 이번 회의에서 다루고 있는 일본군 위안부 영문 자료의 경우에는 일본 제국 군대가 1930년대와 40년대 어떤 식으로 행동했는지를 잘 기록하고 있습니다. 따라서 이러한 국가의 행위에 대해서 국제법적으로 평가가 가능한데 사실상 100년 전이나 지금이나 여성에 대한 인권 문제에 대해서는 여전히 국가들이 국가 중심적인 사고방식을 하고 있는 것이 문제입니다. 아까도 이야기 나온 사항이지만은 적어도 일본군 위안부 중에서 많은 수를 차지하고 있는 한국인 위안부들이 상당히 오랜 동안 침묵했습니다. 이들은 1990년대 이후에 와서야 사회적으로 이들의 목소리가 나오게 되었고 시민단체의 그 여러 가지 도움을 받아서 일본국의 책임을 추궁하는 운동이 시작이 되었습니다. 사실상 한국인 국적을 갖고서 중일 전쟁이나 2차 세계대전 때 피해를 당한 사람들은 강제징용, 강제징집, 강제노동 이런 분들, 그 다음에 히로시마와 나가사키에 강제징용되었다가 원폭을 맞은 피해자들, 그 다음에 사할린 쪽에 또 강제로 이주되었다가 고향에 들어오지 못한 사람들, 이런 분들이 바로 일본군 위안부 피해자와 함께 굉장히 많은 수를 차지하고 있습니다. 이들 한국인 전시 피해자들의 여러 가지 주장에 대해서 일본국은 특히 일본국 입장은 일본군 위안부에 대해서는 존재 자체를 인정하지 않고 있습니다. 그리고 그 당시 일본이 지배하고 있었던 한반도 지역은 일본인과 거의 동일하게 취급한다거나 또는 리퍼블릭 오브 코리아가 신생국이기 때문에 관계가 없다거나 또는 리퍼블릭 오브 코리아가 1965년에 일본하고 국교를 수립하면서 협정으로 최종적으로 완전히 해결했다, 이렇게 주장하고 있습니다. 현재 인권 관련해서는 유엔 회원국으로서 유엔 헌장에 따라서 당연히 인권을 증진하고 유엔의 인권 관련 기관에 협력할 의무가 있습니다. 아시다시피 인권 피해자들은 유엔 인권기관에 개인 청원을 할 수 있고요. 지역에 따라서는 인권재판소도 활동하고 있어서 전 세계적으로는 인권 침해 문제는 이제 매우 보편적인 공통 관심 사항이 되었습니다. 그런데 현재 국제법에 따른다면은 인권 피해자들을 구제하는 제도는 매우 어렵습니다. 예컨대 개인 피해자가 직접 국가를 상대로 해서 손해배상 청구를 할 수 없습니다. 아울러서 일본군 위안부 피해자가 일본에서 지난 수십 년간 소송을 했지만은 구제받은 적이 없습니다. 또한 일본군 위안부 피해자가 미국과 같은 인권 선진국에 가서 소송을 하더라도 예컨대 국가 면제라든지 또는 국가 행위 이론이나 또는 정치적 문제 이론에 의해서 소송을 더 이상 진행할 수 없습니다. 결국은 일본군 위안부 피해자 같은 경우는 국적 국가인 대한민국의 도움을 얻어야 되는데 또 대한민국은 일본 국가의 외교 관계를 고려해서 적극적으로 나서기도 어렵습니다. 제일 일본군 위안부 피해자들의 구제를 받게 하는데 어려운 요인이 되는 것은 2012년에 인터내셔널 코트 오브 저스티스에서 이탈리아하고 독일 간의 소송에서 이탈리아가 독일의 주권 면제를 인정하지 않은 것은 국제법을 위반한 것이다 라고 말한 것이 사실상 일본군 위안부 피해자들에 대한 일본국의 국제 책임을 추구하는 데 상당히 어려운 방해물을 제공하고 있습니다. 그런데 일본군 위안부 피해자와 유사한 홀로코스트 피해자에 대해서는 상황이 전혀 다릅니다. 홀로코스트에 대해서는 전 세계적으로 다 인정하고 기억하고 있습니다. 홀로코스트는 국제범죄인 제노사이드와 연결이 되고 각국의 국내법에서도 홀로코스트를 부정하는 행위는 범죄로서 처벌을 받습니다. 반대로 일본군 위안부 제도는 지난 70년간 일본국이 부정하고 있고 2015년 12월 28일 한일 외무장관 공동 기자회견에서 양국이
denied the
일본군
responsibility
위안부
for past
피해자의 피해를
70 years.
해소하기 위해서 여러 가지 사업을 하기로
And
했는데
2015,
그 내용은
December 28,
바로
Korea and Japan
몇
foreign
주
ministries
후에
had a
2016년
joint
1월
press conference
CERT 인종차별 철폐에
to
관한 인권
investigate
도약에
further
따라
into
가지고
Comfort Women
만들어진
issues.
위원회에서 제출한 보고서에서
But in
일본국은
2016,
위안부
January,
제도 자체를 부정했습니다. 저는 이번 기회를
in
이런
another
행사를
report,
통해서
the responsibility was
미래
denied.
세대에 대한
I'm
교육이 매우
making
중요하다고 합니다. 사실
recommendation
무력 충돌 시에
in the
여성의
following
피해와
four parts.
관련해서는
First,
100년 전이나
there has to be
100년
education
후인
of a
지금이나
future
차이가
generation
없습니다.
in order to
아직도
prevent
현재도
wartime
무력 충돌
woman
시에는
victimization
전술의
of
한
a
방법으로
wartime woman.
여성에 대한 강간 방법이
Rape
활용되고
of
있습니다.
women
강간을 통해서
has been used as
공포를 야기하게 하는
used
것이죠.
as a strategy
따라서 이런
tactic
일은 없어야 되는데 결국 미래 세대를 교육시킬 수밖에 없고 그 교육 자료로서 오늘 그 세미나의 주된 그 핵심이 되는 일본군 위안부 영문 자료와 같은 것들이 많이 마련돼야 된다고 생각합니다. 국가들은 적어도 전시 여성 피해자들을 구제하기 위한 다자 협약을 체결해야 될 것이고 각 국가들이 조약으로 체결하기 어렵다면 각 개별 국가들이 이들 전시 여성 피해자들을 구제할 수 있는 여러 가지 실행을 해야 된다고 생각합니다. 그로써 관습법을 발전시킬 수 있다고 생각합니다. 또한 적어도 일본군 위안부와 관련해서 국내적으로도 일본군 위안부 존재를 부정한다거나 그렇게 된다면 형사 처벌할 수 있는 국내법이 마련돼야 된다고 생각합니다. 시간 관계상 제가 짧게 말씀을 드렸는데 질문과 답변 시간을 통해서 보충을 하도록 하겠습니다. 경청해 주셔서 감사합니다.
Great. Thank you, Professor Kang. Okay, now let's turn to our final panel, which will focus on public education. This panel will be, we'll hear from two people. First, we'll hear from Daniel Diaz, who is the director of UCLA's History Geography Project and a former high school teacher. He is the director of, as the director of the project, he provides professional development opportunities, workshops, and institutes for K-12 science and ethnic studies teachers. And his research interests include the impact of local history on student engagement, how best to support history teachers new to ethnic studies. After we hear from Daniel, we'll hear from Professor Chungmoo Chea, who teaches Korean culture, literature, film, gender, and religious ethics here at UCI. She's our cross-campus colleague. And she is the author of Healing Historical Trauma in South Korean Film and Literature. And she has edited and translated Voices of Korean Comfort Women, which is forthcoming. So let's first hear from Daniel, and then we'll hear from Professor Chea. Daniel.
Thank you, Stephen. Thank you everyone for welcoming me here. I'm gonna go ahead and share my screen. Just give me a second to do that. Okay, great. Okay, well, as Stephen said, I've been tasked to help our audience understand the ways that public educators and history educators engage in learning about comfort women. On the screen, you can see an excerpt from the 1998 California History Social Science Standards. These content standards serve as a guide for history teachers in K-12 public schools. And they are sort of a list of topics to teach. The standards were adopted of a hostile political climate that pitted Republicans against conservatives. And these debates have been dubbed the history wars. My large point about this particular slide is that history and the teaching of history is a political and often politicized subject, that despite the politicization of this particular set of standards in 1998, The final draft still calls on 10th grade world history teachers to teach about the atrocities of World War II, including, but not limited to, the rape of Nanking. We fast forward to 2016, and in 2016, it was determined that a new framework was needed for history social studies. The framework serves as an update to those 1998 standards. This update de-emphasizes the covering of content and instead asks history teachers to teach through historical inquiry in an effort to build historical thinking and literacy skills. You'll notice here, as part of this update, the comfort women were added as a topic to teach. This graphic represents the 4 instructional shifts found in the California High School, the California History, social science framework. Again, the goal is that history teachers take a more holistic approach to teaching history. The content is more inclusive than the 1998 standards. The framework integrates a law called the FAIR Act, which asks teachers to include the stories of women, minorities, Indigenous Americans, the disabled, LGBTQ, and on and on. Please note that this is law and it's a requirement. Much of our work at the History Geography Project is focused on training teachers so that they have the content knowledge to teach these stories, but also that they have the tools necessary to create safe and inclusive classrooms. The framework is also inquiry-driven, inviting more of a focus on critical thinking. And finally, literacy is seen as conceptual and skill-based. A major emphasis is on teaching primary documents. This is also a point that's echoed in the California Common Core Standards for History and Social Science. Finally, the California History framework includes a chapter on ethnic studies. The inquiry questions and the definition are on this slide. I helped to co-author this portion of the California History Social Science Framework. So when we take these 3 important documents together, what we see is that history teachers have been asked to teach about the comfort women and other atrocities of World War II, that they're asked to take an inquiry-based approach to this topic, and they're asked to use primary sources as evidence when they teach. Finally, teachers can, and I argue should, teach history as a means to help students think critically about the present so they can work towards equity and justice in their communities and beyond. So I want to talk quickly about some historical thinking concepts, and then I'm going to give you some examples of what this can look like in the classroom. So when we're teaching about topics like the comfort women or other atrocities, we want to think about historical significance. These are concepts that we tell students that historians use to approach their topics. When we look at the past, we look at it through, we call them the big 6+1. They're pretty straightforward. I think considering who we have here in the panel and the audience, a lot of these will resonate. When we talk about evidence, we're talking about sourcing and inferences and corroborating documents and asking good questions of the source. When we talk to students about continuity and change and cause and consequence, we're asking them to make sense of the flows of history and the bigger impacts that decisions and moments have on other decisions and moments. Historical perspectives is really important here. One thing to consider as we talk about this particular topic is how can we understand the experiences of the comfort women? The ethical dimension is asking us how knowing about the history and the experiences of the comfort women can help us make sense of the present. And the activist dimension, in the tradition of activist historians such as Howard Zinn and present-day historians such as Dartmouth's Matt Garcia and UCLA's Kelly Lytle Hernandez, asks students to think about the ways that they can use history and research of history to create more just and equitable societies. I want to stop here and just make a couple of points. K-12 classrooms are their own ecosystems. They can be places of liberation, creativity, and community. However, in the worst case scenarios, they can be oppressive and unsafe. It is important for me to say that in order for a teacher to teach a sensitive topic like this, they must have created a safe and inclusive classroom to give this topic the care and respect that it deserves. This means that teachers must be aware of how they talk about sexual abuse. They must be aware that often there are victims of sexual abuse in their classrooms. While teaching sensitive topics like comfort women, I recommend that teachers take a trauma-informed approach. This means thinking deeply about the topic, about the community that you're working with, providing learning opportunities for students to not just learn about the topic, but to engage in some activities that allow for them to take action and to even take part of the healing process. I'll talk more about what that looks like in a minute. Some recommendations. I do not recommend that teachers overstimulate students with imagery or accounts that contain graphic images or references. I see this far too often in classrooms. Photo after photo or document after document can often desensitize kids to a particular issue. One or two sources can more than serve the purpose. Secondly, I do not recommend that teachers use bad inquiry questions that can be answered with yes or no, responses. Questions such as, do the comfort women deserve justice, or should we support the comfort women, are not only poor historical inquiries, they also have the potential to create classroom discussions that pit students against one another and allow for some students to answer in the negative. I'm sure you can all see the kinds of problems that can result from asking questions like this about sensitive topics like the comfort women. Third, I do not recommend that teachers engage in historical role play, such as mock trials. Asking students to reenact the trauma of others can be disrespectful and can also cause additional trauma to students who have been, in this case, victims of sexual abuse. However, I do recommend that teachers, when possible, include examples of resistance and resilience. And I do recommend that teachers provide students with learning opportunities that allow them to engage in movements to support, in this case, victims of sexual abuse. So in this example, all of that being said, here's an example of a well thought out unit by a local history teacher. This unit is part of a larger unit exploring World War II. The unit emphasizes the concepts of evidence, historical perspectives, and the activist dimension. The unit is driven by a bigger question: how can we confront the atrocities of World War II? The use of the word confront was intentional. We're not asking students to remember the atrocities or understand them. That is vital to answering this question. Confront is in the spirit of resistance, standing up to something, stopping something. It's the opposite of avoidance. And so the teacher was very intentional with this question. As the students go through this unit, they will first learn about the atrocities that occurred during World War II. This is things like the rape of Nanking, things like other just horrible experiences that happened, not to overstimulate or sort of desensitize students, but just to help students understand that this is something that unfortunately is quite common during times of war, and especially during the age of empire prior to World War II and during World War II. The second lesson in this unit is asking students to think about evidence and to reviewing evidence of resistance to atrocities during World War II. Sorry about the background noise. When we're looking at evidence here, we're looking at particular historical thinking guideposts, especially guidepost 1. Students are making inferences based on primary sources. These can be accounts, relics, or we even say at the History Project, they can be oral histories, testimonies, art of, and including art of from survivors. And we've seen a lot of amazing art from the survivors, from the comfort women survivors. The fourth lesson is connecting the experiences of the comfort women to the experiences of other victims of atrocities during the war. Teachers can go as far as experiences in Vietnam if they want to span different historical eras, such as Operation Baby Lift. And then the final lesson is taking the activist dimension. How do we confront and heal and remember these stories? What can students do now that they know about this to make sure that we're working towards equity and justice for victims of sexual violence, right? Right, so the guidepost for activist dimension is saying that history shouldn't provide answers to modern day problems, but it can inspire informed action. And it can, again, help us work towards a more just and equitable society. So I'm gonna go ahead and conclude with some examples using the archives. I have some examples here. Is me playing the role of student, doing some annotation. So this is a photo of Japanese prisoners of war, and it was photographed by U.S. Army Signal Corps photographer Charles Hatfield. The source information is there. And the annotation strategy asks students to analyze this photo using a strategy developed at the University of Michigan by Chanti Montesano. You'll notice here that the student is asked to consider the point of view of the photographer using the sourcing information to help them with their analysis. Students are asked to pay special attention to key details. Here, the student is contrasting the faces and expressions of the women to the soldiers. They are curious about who the soldier is. They have a hunch that this might be an American soldier based on some context clues. They're not quite sure. More importantly, the students has noticed that one of the comfort women appears pregnant. This is an example of a Netherlands Forces Intelligence Service report from 1944. In this report, observations and intelligence revealed the creation of revealed the evidence of comfort women who are being used in, I believe this is in Java. And you'll see the students' annotations there. And continuing on, the students are using evidence to learn about this. My final example is a student looking at this amazing piece of art called Stolen Chastity. Dr. Sean Ginwright is spearheading work in ethnic studies, and Ginwright argues that classrooms could and should be spaces for hope and healing. His karma framework states that art and culture can be tools for hope and healing. We often see victims of atrocities from war engaging in healing processes via art. We see this in the art that came out of World War I, the art of the survivors from Hiroshima and Nagasaki. We even see it in the recent performance. Some of you might have seen this by the Chinese-American teenage rock band from Los Angeles, the Lisa Lisas, who performed at the Los Angeles Public Library and did some songs about their experiences with racism amid the COVID-19 pandemic. We also see art as healing and remembrance in this piece called Stolen Chastity. Right? And so how can we make sure that we remember these stories? Art is an amazing way to do this. And again, the student is analyzing the art using their sort of historical of this topic and drawing out what they see here, the roots and the skulls in the bottom, which have been highlighted. And they even gave it a title, but what they is the painting. Okay, so as you can see, exploration of archives and approach to teaching the subject. We can and should be teaching about this in history classrooms across the state of California. Thank you so much.
Thank you, Daniel. It's very informative. I found myself, even as a law professor, trying to make notes of how to translate this into my own sort of teaching with law students. So very, very informative. So with that, we'll turn things over to Professor Che.
Well, Thank you. I just learned a lot from all the presenters, and thank you so much for inviting me to this panel. And I'm not a legal scholar or no pedagogist. I'm just teaching culture and literature. And so I'm going to approach from my kind of expertise. And as Professor Lee introduced, I recently, well, not recently, it's been a couple of years, translated the volume of the Comfort to Women testimonies that includes 9 testimonies, and that was collected back in 2000 for the occasion of International Tribunal that Professor Hoffman mentioned. And so my purpose of doing that is it is just a part of the community education project, so to speak, to let the public know what the stories of the victims are. And so sort of I'm approaching from that perspective. Before I get to that, the public education point, I just wanted to quickly mention something about the Ramsey article. Everyone, when that article, the Contracting the Sex for in the Pacific War, came out, many historians and legal scholars were arguing not only about the validity of the contents of the article, but also about the existence of the work contracts. And apparently, Professor Han did mention that some of them did exist. But for me, it was a very simple kind of answer, because learning about the life of these people, and which perhaps in the legal field would consider as a sort of a secondary source or supporting evidence, rather than the primary sources, but it is a primary source in a sense. Ramsey spends a lot of the generous portion of the article presenting what appears to be an imaginative, what I consider to be imaginative context of contracted drawing. And in that, in this kind of a contracted drawing context, which he describes that 2 parties, the brothel owners and the girls, assumed to be on equal footing. The way that he describes it is that both parties are negotiating the prices and terms of work, including the duration of work, or based on the given working conditions. If it is long, then more, etc. So with this kind of, I guess, information, Ramsey also presents that the women whom he defines as prostitutes had their own agencies, with power and authority to represent their rights, their interests, and certain measures of self-protection. But knowing the colonial situation, such freedom and rights given to especially colonized Korean girls, mostly of rural origin and from lower socioeconomic strata, those freedom and rights were inconceivable under the particularly harsh Japanese the colonial rule, especially during the Pacific War years. In addition, a simple fact check regarding the literacy level among Korean women at the time would lead to a conclusion that these girls were unaware were unable to read and understand the legal terms of the contracts, let alone negotiating in defense of their welfare and human rights. In fact, many former Comfort women have remained illiterate, and that comes out very clearly in these testimonies. The life stories of the Comfort women, they did not, most of them did not receive zero education and remained illiterate throughout their lives. In fact, official statistics of women's literacy rate in late 1930s during the Pacific War was 16.4% of literacy among the women between at the age of 15 to 19, which drops quickly to 10% in the 25 to 39 age group, and 6.5% to 4.7% for each ascending age groups by 10 years. And in another survey, national survey at that, in 1930, 236.56 out of 1,000 Japanese women who lived in Korea were completely illiterate, while 920.47 women out of 1,000 Korean women were illiterate. The literacy survey included the questions whether it's not just complicated reading skills, it's just whether or not one can read either kana or Hangul, the alphabet of a respective language. So in addition to the colonial labor law, I think Professor Han mentioned the 16 or whatever, but for the Japanese prostitutes, that's the legal age was 18, but for the Koreans, it was lowered by 16, and the ordinary workers, the minimum work age was lowered to 14. But such ordinances were routinely violated. For instance, the children around 8 to 9 years were preferred at the silk factories because of their nimbleness of their small fingers to extract the silk thread out of the boiling cocoons, so that many of them had the fingerprints smudged. And the famous novel called Sangnoksu, which was written by Shim-hun, published in 1935, is set in the context of the Vinarud movement, which is a literacy campaign to bring up literacy rate among the children without schooling in the rural area, which further corroborates the dire situation of the time when Korean girls were taken to the war front as comfort women. So my point is that these primary sources, such as survivors' life stories, rather than just fact-focused testimonial documents, and other supporting materials such as literature, would contribute to setting the record straight in a way that is quite powerful and persuasive. Having said that, now I turn to the question of education of the public on this comfort women issue. In the interest of time, and Professor Diaz already covered very detailed, so I just share what we did last year. As I said, the translation of testimonies were in English, was for the purpose of the community education. So I found one of the largest publishing house in England to get it published. And for that, besides the body of that, I decided to add a set of discussion questions, so that when they read, they would not just read through, but actually have some discussions. So for that, I thought that high school teachers, since already in California, the high school teachers were to teach in the world history class, 10th grade world history class, these materials. So we organized at the Center for Critical Korean Studies, organized a workshop for the California high school history teachers. And as I said, the goal of the workshop was to produce a set of teaching kind of discussion questions. So for this workshop, we invited several New York City University professors in education and who have been developing high school the comfort women curriculum for care some years ago. And so they and I and some of others worked together to set the category of questions. And I realize now that follows very closely what Professor Diaz just described. And we had more than not just 7 categories, but 8 categories. And so some of the categories of the questions are the nature of human rights, feminist issues, and memory and how it functions, which is an important aspect for oral history, and results of trauma and Korean culture, Japanese military and colonial policy, and resistance as with important one, and the legacy of war. So under each category, the teachers came up with essential questions and developed extension or sub-questions that go with it, and to delve even further, explore even further. So some of the questions, the by the way, the workshop itself was small. We advertised it for the whole month, but the participation rate was small, so this is a small sample. But so some of the questions are in respective category. I just read them. What evidence exists in the testimonies of the comfort women that proves their human rights were violated? Why would the comfort women feel ashamed for something that they didn't do, but have done to them? What does this tell you about the woman's role in society? Oh, what I forgot is that we had them read some of those testimonies we selected that would not include violent languages, which is quite often. So we sort of selected some stories and had the teachers read and then come up with these kind of questions. And we had during the workshop we discussed each question. How you think these testimonies might have been affected by the passage of time, and what other factors might influence memory? How has a transgeneration trauma affected comfort women and their families? How did societal pressures and cultural expectations impact these women? Or how did the comfort women system reflect the Japanese military and colonial policy? How do acts of resistance help people deal with and survive an experience such as this? Or based on the testimonies, how was displacement of people as a consequence of war? So although the sample size is very small, the range of these questions suggests general I hope that they suggest general interest of the US public in the issues on the issues of comfort women. And this set of questions show a marked difference from the questions set for the curriculum in Korea. I must confess that I have not had a chance to examine Korean high school textbooks on comfort women closely. However, a cursory look at the list of guiding questions posted on the Comfort Women e-archives website on the Korean Ministry of Family and Gender Relationship, one senses some differences in the goal and orientation for public education. The guiding questions for students are something like, who awarded the comfort women? How did they become comfort women? How did they suffer? What has the comfort women movement accomplished, etc.? So these questions reflect whether the Korean public interest may lie or the goal of the Korean government for the education of the public, it shows. So mainly, those are sort of mainly to expose the history of wrongdoings and the unfolding of the comfort women movement, and toward hopefully the redress. So I do not have time because we already pushing to the limit. So I do not have time to analyze the differences. So I just leave them to you. And these differences seem to manifest in academia as well. Recently, I had opportunities to participate in a panel on comfort women at the AAS annual meetings, which is the Association for Asian Studies meeting, the largest meetings for the Asian Studies specialists in the US and presumably in the world. And so this panel consisted of researchers from Japan, Hong Kong, the Philippines, and other Southeast Asian countries. At the opening of the panel, the organizers subtly implied that Korean comfort women movement has set its own course and agenda, and therefore this panel had been formed across national borders outside of Korea to examine the feminist issues, which was it requires a lot of sort of thinking. But this led me to think about the second question, the necessity of building a broad-based coalition of women victims of wartime sexual assault and rape. Actually, in conjunction with the workshop, I organized the international conference on not just to redress, but to look forward as to what to do with this kind of issues. So comfort women's stories alert us to the tragedies of thousands of women whose voices and whose voices the world rarely gets to hear. In the mere 7 decades since the end of World War II, there have been quite a few cases of mass sexual violence against women, an estimated number of between 250,000 to 500,000 women were raped and mutilated during the Rwanda genocide in 1994. The ongoing rampant and systemic rape and the brutality against women by militants engaged in the internal conflicts of DR Congo and the wars in the neighboring countries, the estimated 50,000 girls and women captured, etc. So the list goes on to Bosnian War between 1992 and the 30-year-long civil war in Sudan, and also the girls who were abducted and raped in Nigeria by Boko Haram, rape and abuse of Muslim Rohingya women by the Buddhist military forces in Myanmar, and also women who were subjugated, especially Iraqi and Syrian girls who were subjugated to IS since 2013 until recently. So the UN recognizes this systemic rape and as a weapon of war. The rape of women makes a particularly effective weapon because it not only destroys its physical victims, but it destroys entire communities as well. So
지역사회를 와해하기 때문입니다.
the history of the plight of women in war zones of the past half century, and so the list goes on. So recognizing the heroic fights by a few individuals against such atrocities, the 2018 Nobel Prize was awarded 2 individuals, Nadia Murad and Denis Mukwege. Nadia is a young Yazidi woman who was raped and enslaved by the IS militia, but escaped to let the world know of the atrocities. And Denis is a gynecologist from the Democratic Republic of Congo, who has been trained to treating the female victims of wartime sexual violence. So the issue of wartime sexual slavery of women is a critical, the human rights as well as a feminist issue that must be addressed with the utmost urgency. And so in light of this long history of atrocities against women across the world, regardless of race, ethnicity, and or religion, it is essential that public awareness be raised. So the testimonies of Korean survivors of sexual enslavement available in English is thus imperative, and as such will provide important source of source materials for the investigation. And hopefully that will help move us forward, seeking of justice, the healing of trauma victims, the stopping of sexual enslavement, and eventually the restoration of the communities. And that's what I think what the this public education, the direction of the public education should go. And I think that that's all I can say within time, because I just
Right. Great, thank you, Professor Che. So at this point, we have about 7 minutes left. I'll ask our participants to please turn on their video cameras just for this final portion. So what I'd like to do is just briefly offer 3, I think, summary points, and then I'd like to sort of pose a question for the group and give them a chance to respond, you know, to the extent that you feel inclined to do so. So I learned a lot from the presentations. I think all of us did, and I hope that our attendees did as well. But if I were to try and distill our speakers' points down to a few points, I would say that there were 3 takeaways that I think overlap. So one is that the challenge in this space is trying to translate a memory into history. That is, memory is a kind of subjective reality, something that we all experience and we know, but one that's uncoordinated and disparate. History, by contrast, is an attempt to try and collect this and really relies on the authority of the speaker. So fundamentally then, I think the challenge is trying to assert power to take on the voice of an authoritative figure so that this sort of legacy of that is currently existing as a memory lives on as history. So that's sort of one, I think, a set of points that many people made. A second is to identify the role that law has played in this and fundamentally the limits that law offers. There's only so much that law can do, and you know, my colleague Paul, even in his admission, someone who's an optimist, recognize that there's it's a sort of narrow road ahead. So as we think about mobilizing in this arena to try and make interventions, law has to work in conjunction with political organizing and amassing power and building coalitions and reaching out to various stakeholders. And I think many of the questions in the Q&A also speak to that. The third and final point, and I think the one that is perhaps most relevant to the database, is that the comfort woman example illustrates how violence can become normalized. And I think I think Dr. Han's presentation most directly spoke to this. It reminded me of Hannah Arendt and this, the banality of evil, and how just over time people become desensitized to this, and it becomes a part of the water we swim in. And so that is a challenge. How do we try and take these lessons from the past and stay vigilant so that the current moment doesn't become another moment of normalization? Okay, so with that, I just want to pose a question to our panelists, and anyone should feel free to answer this. I guess the question is, what does victory look like? How would you define victory? Is this, and I think a sort of, is this a sort of a recognition by the Japanese government? Is this a sort of a fight about monuments? Is it a court case? I would just love to hear from the various perspectives, educators, lawyers, advocates, historians, how you define victory here, and relatedly, what does the timeline look like, right? What are we looking at in terms of how we can expect to do this? Is this a couple of years? Is this a generational battle? I would love for people to answer this. And I think Phyllis, I think you had indicated that you had some comments that you wanted to share, but others should also feel free to chime in.
Yes, thank you, Professor Lee, and thank you all panelists for your wonderful presentation and thoughtful, thought-provoking remarks. And I really appreciate your presentations. Well, the point I wanted to make before I answer Professor Lee's question that he posed is that, we tend to look at this comfort women issue as a Korea versus Japan dispute, a historical dispute or diplomatic dispute between the two countries, which is very, very wrong. And I cannot emphasize enough that, this was an atrocity that was committed against women from more than 30 countries, including the US. The nurses from the US under the Red Cross were victimized, and the European women were invariably victimized when they became the prisoners of war. So we really need to understand and remember that the victims do not stop at the border of South Korea, but that there are victims who are who are still waiting for justice in vast countries. So that's one thing that I wanted to emphasize. And many people asked about the availability of the data that were translated, and actually the translation has been completed. And we are building the website right now. So we have the overview, we have the map of the comfort stations created by WAM, W-A-M, a museum in Japan that has been doing great work over the decades. And we have the annotations of the primary sources, including the Japanese military documents and the Allied forces documents. But we also have the translated materials for the documentaries featuring survivors and the witnesses, such as the military doctors and medics during the war. So this, the subtitles will be provided for these documentaries. And we also have materials for the 2000 International Women's Tribunal and explanation of the Tokyo Tribunal and why it was not included in Tokyo Tribunal and Batavia trial as well. And we also have materials for the movements that have been going on in the world around the globe. And we also have artworks and videos and a list of books that will be helpful for teachers to navigate, and books for young adults and students as well. So, and we also have teaching materials such as lesson plans, and teachers can pick and choose whatever we provide and come up with their own lesson plans, according to what Dr. Diaz has explained in his presentation, which was immensely helpful. About what was the question, Professor Lee, you posed? I'm so sorry.
I was just asking what victory looks like. What is the time and what is the timeline?
That crucial question. Yes. I think, there are 7 demands posed by the victims who have created an international solidarity back in 1990s. And the 7 demands include
7가지 요구 사항이 있습니다.
investigation and the punishment of the criminals, and public education ongoing basis, and then public memorials and museums and things like that. So, basically what a victory looks like is what the model has been provided by the German government, how Germany resolved the Holocaust I think is the model for this kind of atrocity, and the large-scale human rights violation can be resolved. And what we look at, what American government did for the Japanese internment camp atrocity, I think that also could be one of the models when it comes to resolving the issue. The timeline, I think there's no such thing as a timeline for this kind of atrocity and the resolution of such atrocity, because, American slavery has ended a few hundred years ago. However, we never believe educating what happened in American soil can now be forgotten. Now we can dismiss what happened. No, it is still an ongoing issue that is very important for all Americans, and everyone in the world need to learn and remember. And there must be ongoing efforts to address this kind of problem so that it doesn't repeat itself. I think it's really important issue that is still ongoing, and because we still face sexual violence during wartime against women around the globe, and human trafficking in our backyard. So I think it's really important that we make efforts to teach our community and children about this issue. Thank you.
Well, I can't think of a better place to end. And in any event, we're over time, but I just love that tone that Phyllis struck. Now, before we part ways, I just wanted to very briefly recognize a few people. I wanted to thank Erin Hebert, UCI Law Center's coordinator, for logistical support. I want to thank Rabi Kadri, our Law Center's manager, who also helped in the organizing. I want to thank Stephanie Lee, the program director at CARE, who also did a lot of behind the scenes work. And finally, I want to thank our 2 fearless interpreters, K.S. Park and Yoon Hee Lee. Thank you to them for allowing us to have a global cross-border transnational event. Very much appreciate that. So anyway, to our attendees, thank you for joining us. To our panelists, thank you for sharing your thoughts. I hope that someday soon we can gather in person, and until then, stay healthy, be safe, and keep fighting.